Hey guys, welcome back. Joe Brunsman, insurance broker to the stars. Today we are talking about when good enough isn't good enough. So if you're a business out there and you think, hey, I got the little shield on my website from this third party, or, we've met all our, stated regulatory requirements, we're good to go. Well, here's a real legal case I think every business needs to understand, because what we thought used to be good enough, it doesn't look like it's good enough anymore. And that's a big potential risk to your business. All right, so what happened in this particular case? This is Clayton v. Pruitt Health out of the U.S. District Court, Northern District of Georgia. Pruitt Health suffered a November 2023 cyber attack. Hackers stole data on roughly 50,000 employees and patients. And the hackers, they go, hey, we're going to publish this data on our website unless you pay the ransom. Now, on an interesting twist, Pruitt Health's own forensics team couldn't verify this. We don't know if that data ever got published on the website or not, because the site was actually taken down. So we have no idea there. So what does this mean? Hey, this could happen to any business. Now, this is healthcare, but really any business, if you have employee or customer data that needs to be protected, you are at potential risk. So here's the lawsuit and why it matters. So Clayton was in particular a former employee, not a customer. That's going to be important later. She sued for negligence per se, and breach of fiduciary duty. Now, I'm not going to get into the legal definitions here. I'm not your attorney, but suffice to say, Pruitt Health tried to dismiss that case early, as all businesses would. And they said, hey, the plaintiffs here haven't shown that they actually suffered any harm. There was nothing that I could find in any of the court documents where a plaintiff could point to, hey, my identity got stolen, someone got into my bank account, someone opened a credit card in my name. There was nothing to that effect here. Now, the court denied dismissal on the negligence claim specifically, so that one got to go ahead. And she said, hey, there is substantial and imminent risk of identity theft and fraud here. There is foreseeable harm. So what businesses need to know is, just because no one's called you and said, hey, my identity got stolen, that doesn't mean that they can't sue you for creating that risk of inadequate security. Now, the alleged security failures, this is according to the plaintiff here. Foremost, they're saying like, hey, Pruitt Health failed to comply with kind of industry standards such as the NIST cybersecurity framework or CIS framework. So those are two things. If you're just a normal business watching this, go out to your MSP, talk to your IT guy. Those are widely available, easy to find, and very, very useful for you. And they could be Exhibit A if you fall victim to some event like this. Now, the specific failures: failure to adopt adequate security measures, monitor security, destroy PII after its purpose was utilized. So that's a thing I think a lot of businesses are having trouble with, is all of this data never ending. If you don't have a legitimate purpose for that data anymore, a legitimate business purpose, please consider getting rid of that stuff. Moving on here. She goes, hey, you allowed unauthorized access to my PII. You failed to timely detect this particular intrusion. You failed to timely notify the class members, and failure to secure standalone computers, which is a kind of a weird tangent that I will not dig into here, but it was kind of interesting to see. So what is this reasonable foreseeability standard? Well, what the judge is saying here is, hey, Pruitt Health, they collected the data. They created the danger by storing the data, and cyber attacks are reasonably foreseeable. Therefore, Pruitt Health had a duty to protect against those foreseeable risks. Now, you notice the judge here is not saying, hey, Pruitt Health had a duty to meet the minimum regulatory cybersecurity requirements. The judge here is saying Pruitt Health had a duty to protect against these foreseeable risks. So if your industry is commonly targeted, which I don't know any industry that is not, a court can and may expect you to take reasonable precautions. So minimum compliance isn't necessarily enough when the threat is foreseeable. So what does the term reasonable mean? Well, that's like the bane of every first-year law student's existence. The short answer is it depends, but it's going to depend upon what industry you're in, the type and the amount of information you hold, et cetera, et cetera. Now, why minimum compliance may fail. Well, let's talk about what did not save Pruitt Health. They dismissed the HIPAA negligence per se claim, but that's because Clayton wasn't a patient. They dismissed the FTC negligence per se claim because she said, hey, employees aren't consumers. This isn't going to fly here. But the judge went on to say, hey, regulatory compliance, that's just a baseline. So courts are now looking at what's reasonable given those industry-specific threats, not just what is mandated in some piece of paper somewhere that some regulator put out. So yes, standards do matter. The court specifically named the NIST cybersecurity framework, of which Pruitt Health allegedly failed to comply, and these CIS critical security controls, once again, Pruitt Health allegedly failed to comply to those. So these standards, they do exist for a reason, and I want every business out there to go, okay, is it possible that we could actually map to these frameworks? Talk to your IT folks, talk to your MSP. These frameworks, they might sound fancy, they might be completely foreign to you as a business owner watching this. Nonetheless, they're widely available, easy to find. I won't say they're easy to implement, so yeah, you might pay a little bit more to do this, but they are very, very useful, really for multiple purposes. All right, before we get into what actually happened here, today's sponsors, CCA, Ciardi and Aston, lawyers for the situation, as well as X-Clause if you were just looking for an MSA and an SOW. All right, moving on here. Let's talk about the swing and a miss. So Pruitt Health, I could not find anywhere where they claimed, hey, we were compliant with NIST CSF or CIS or any other framework. They weren't even trying to go down that path. So me kind of reading the tea leaves here, I would go, maybe there was a problem there and they didn't have that type of documentation, because Pruitt Health's defense appeared to focus on denying that Clayton suffered any injury, which we already saw that didn't fly, that they owed a duty to protect her data, which it seems like they're grasping at straws. Probably not something I would allege, but nonetheless, that's where they went. And then denying causation. So without mapping to a framework, your options are pretty limited. So when you have that framework, say NIST CSF, it's like 150 some odd line items last I checked, you can actually go through and say, hey, here's what we were doing, here's why we were doing it, or we didn't implement this line item because of XYZ reason, or hey, this next line item, we were thinking about implementing it, or it was in our plan, we just didn't have the budget for it yet, and they hint us in the interim. But if you don't have a framework, trying to go through that exercise to prove that you were taking this in a serious and responsible way, I think is going to be much, much harder, nay, impossible. So what ultimately happened here? Well, the negligence claim could proceed to trial. The judge ruled on that, and the case moved to discovery. So what did the plaintiff actually want to see? And this is something I think everyone should write down, because this could be kind of exhibit A. So you want to make sure that these particular documents are in order for your business. So they wanted the data storage policies, procedures, and training, the data security policies, procedures, and training, employee training on security, which, please don't let employees miss that one, and the breach investigation as well as a few other things here. So those are the types of documents that most businesses, after they've had an event, don't want to be let out to the world. So what does that mean to us? Hey, have these things in place, make sure they're squared away, because if you do have an event, you might be called on to produce those documents, right? It's not just your MSP saying, hey, here's a document, here's all these, kind of cool templates we can offer. No, there actually is a reason for this stuff. So what happens then? Well, Pruitt Health would then need to prove that they met the industry standards, but you got a problem there because the judge kind of put the axe to that. So both parties ultimately reached a settlement. Now, that settlement is sealed. I have no idea what was in there, who admitted what. That is lost to the court system. All right. But a court finding that you violated industry security practices is going to be expensive. So it's expensive enough that even Pruitt Health, with probably really deep pockets, and their law firms were not some dude that hung a shingle. These were major law firms. They still chose to settle rather than defend a trial. All right. So what does that mean for your SMB? It means if you get hit with a data breach class action, man, you're going to be in for a rough ride. And there's probably a pretty good chance you're going to be shelling out some dough for this. So if you're interested, actually right above me here, I will link to a video where a steel lamination company only had 5,000 records and it was just employees that got stolen. They still got hit with a data breach class action. So if you're in a regulated industry and you have, say, 5,000 or less records, don't think that you can just hide under the radar. They might come for you as well. So what are the big takeaways here that I think every business should know? Hey, that minimum regulatory compliance, that does not equal lawsuit protection. Just because you got the little shield or the piece of paper, that doesn't mean you can stop looking at what you might need to implement on the cybersecurity side. That also means, hey, for you IT professionals out there, you got to get this information out to the C-suite. Now, I understand it's frustrating because, they're doing something completely different in the business, and IT is sadly, and I think unfortunately, always seen as like kind of this black hole that people throw money into. But you got to keep on top of things. This is an ever-moving target. Foreseeable threats mean you have a duty to take reasonable protective measures, and I think you should map to a framework to help demonstrate that. Negligence claims can proceed even if there's no evidence of theft or some type of harm befalling the plaintiffs there. And litigation is ultimately really, really expensive, and it is a giant time suck, and it is phenomenally stressful, and you just don't want to be a part of that. So do everything you reasonably can beforehand to try and avoid the event from occurring. If it does occur and you're in this type of situation, we already went through, hey, what types of documents do you think that the plaintiffs might try to pull from you, and get those things squared away. All right, get them squared away. Now, if you're an SMB and you're going, how do I even begin to attack this problem? Go to your MSP, ask to map to a framework, and the most impactful question you can ask from a non-technical perspective is go to your IT folks and say, hey, what's the biggest bang for the buck to increase our security? And all of us nerds out there will be more than happy to wax poetic about all the coolest, latest, and greatest things that you can do there. All right. If you enjoyed this video, please like, share, comment, subscribe. Right above me here, I will put that unglamorous, tiny data breach class action claims. You can watch that next. And if you click over there, you can subscribe to my channel. All right, guys, with that, stay safe.